This is just to introduce. This is Mihir Shah, and I run a company called Services for NRI, and we assist NRIs who based across the globe to do any sort of transaction back in India. And since the situations are how the situation is, so we thought we should start this knowledge series where we talk about what are the legal issues NRI faces in India, and we can give you some guidance and some insight in the knowledge. So with us, we have Monisha. She's a lawyer. She's working as a lawyer for last 15 years, and her specialty is that she's take care of NRI businesses only and NRI matters.
I'm Monisha Mahajan. We work for non-resident Indians. Like Mihir has already given you a brief introduction about himself, and I also work on the same lines. I work on the legal side, whereas Mihir works on the transactional and the documentation sides for non-resident Indians. I work completely on the legal side, people who've got any issues back home in India, whether it's land, property, taxes, or any such related issues. I and my team looks after that. I've been working for non-resident Indians. The key issues we have, key points that we are going to be taking up today are inheritance laws, illegitimate children, and rights of daughters. So why? Okay, so the first topic we start with is inheritance laws. Inheritance laws are very different than what people assume. People living abroad assume कि जो inheritance बाहर होता है वही inheritance laws India में follow होता है. So what people assume in most of our clients come back to us and assume कि the property or any asset which is left back by the deceased is owned by his spouse automatically, because that is the law which is mostly applicable in the Western countries. Whereas inheritance laws in India are totally different. Inheritance laws, there are acts, there are religions, and the inheritance laws are based on personal laws of each person. So if there is a Muslim, the law applicable is the Muslim law for inheritance. If it's a Hindu, a Sikh, a Jain, a Buddhist, a Parsi, the law applicable is the Hindu law. If it's a Christian, there is another act which is applicable for succession. Inheritance laws, I'll go deeper. A person, let's say there is a Hindu person who has died in India, abroad, in UK, and he's got property or any kind of estate back home in India. His property is going to be divided amongst all the children, his wife, his widow, then his mother, in equal shares. Meaning thereby, if a person, a male, now I'm going to, because this also gender wise bhi change ho jata hai, religion wise bhi change hota hai, and gender wise bhi change hota hai. So for a male, if it's a Hindu who has died, his property goes to his mother if she's alive, his widow, and his children in equal shares. So if there are 5 children, 1 widow and a mother, the property will be divided 7 ways. If there are 2 children, 1 widow, no mother, the property will be divided 3 ways. It is not assumed कि अगर mother की death होगी है तो mother के legal heirs को मिलेगा, वो नहीं है. If the mother has died before the son, then nobody gets anything. So mother का right, she will not have anything to do with the property, or her children, her legal heirs will have nothing to do with the property. The only people who will get are the existing legal heirs. So a widow and children, everybody gets a right. If let's say a son has died, a son has also died, but he has grandchildren, then the grandchildren will inherit the son's share. So suppose एक बेटे को 1/3 share आना था property में और उसकी death हो गई है, तो उसकी family को वो 1/3 share पूरा inherit होगा. ऐसा नहीं है कि बेटा मर गया तो उसका राइट नहीं है, उसकी फैमिली का राइट नहीं है, उसके बच्चों का भी राइट बनता है. अब हम आते हैं, एक लेडी की डेथ होती है, अगर वो लेडी है, इंडियन प्रॉपर्टी है, तो उसकी प्रॉपर्टी कैसे इनहेरिट होगी एज पर हिंदू लॉज. सो उनकी प्रॉपर्टी ऐसे इनहेरिट होगी, उनके बच्चों को, अगर तो उन्होंने खुद कमाई हुई प्रॉपर्टी है या उन्होंने अपने हस्बैंड से इनहेरिट करी है या उनकी हस्बैंड की फैमिली से आई है, तो वो प्रॉपर्टी उनके बच्चों और उनके हस्बैंड को जाएगी। अगर वो प्रॉपर्टी उन्होंने अपने पेरेंट्स से इनहेरिट करी है एक लेडी ने, तो वो प्रॉपर्टी सिर्फ उनके बच्चों को जाएगी, उनके हस्बैंड को नहीं जाएगी। एंड इफ द लेडी ओनली हैज वन हस्बैंड लेफ्ट and but she has inherited the property from her father, the property will not go to the husband again. वो property उस lady के parents की family को वापस चली जाएगी।
So Monisha, I understand that the laws are different as well, the gender wise. So the laws are also different as per the different states in India, or is it like across India the laws remains the same? I had got a question from one of the participants, so I thought let me ask you in that.
Okay, me very interesting question. Laws are same everywhere. Like this act is applicable everywhere except Kashmir. Kashmir को apply नहीं करती है, Jammu and state of Jammu and Kashmir को. But otherwise laws बिल्कुल, क्योंकि एक हिंदू succession act है, एक मुस्लिम personal law है, जो पूरी इंडिया में कहीं भी किसी भी स्टेट में आप हो उनको अप्लाई करता है. So mostly how the law is applicable is based on the religion or your personal religion that you follow. It is not based on the state that you are in.
So yes, so you're saying that the law remains same across India, but as per the religion, the law changes, and accordingly you have to get the inheritance law. So we understand that. But now also the question arises on that in a lot of this in a Western world, when there is an inheritance there is a lot of tax has to be paid if not proper planning has been done. So is there something similar in India as well, or is some different aspect in India in that way?
In India, we do not have inheritance taxes. There are no inheritance tax that is applicable in India. Whereas whereas as far as I understand, UK में inheritance tax is applicable. India में tax उस time पे applicable है. Suppose अगर आपके father की property है जो आपने inherit करी है, आप उसको कल को बेचते हो, जो आप उसके ऊपर कैपिटल गेन टैक्स पे करोगे वही टैक्स आपने पे करना है, आपने इनहेरिटेंस टैक्स कोई पे नहीं करना है. दैट टैक्स बिट वो ऑफ कोर्स जब आप वो पैसा, आई एम अज्यूमिंग आप यूके लेके आते हो, दैट टैक्स बिट यू विल हैव टू डू डील विद इन योर कंट्री ऑफ योर रेजिडेंस, but nothing to do with India you are not liable to pay any inheritance tax.
So I understood that taxation there is no tax in India, but if in UK or in UK as well, if you do a proper will and then there are the ways to structure the tax aspect as well. So if somebody is living in UK and who has a will which mentions his or her Indian properties or assets or movable or immovable assets, will that UK will be considered as per Indian laws to the for the inheritance purposes?
मीर बहुत अच्छा क्वेश्चन पूछा है, बिकॉज इतनी प्रॉब्लम होती है ना हम लोगों को इस पॉइंट पे डील करते हुए. जो विल यूके की है ना, ऑफ कोर्स इट इज एप्लीकेबल इन इंडिया, ठीक है. अब होता क्या है, उस विल को प्रूव करने के लिए एज पर इंडियन लॉ, अगर आपको वो विल यहाँ इनहेरिटेंस उसके बेसिस पे चाहिए है, आपको उस विल को यहाँ से कोर्ट से स्टैम्प कराना पड़ता है या ऑथेंटिकेट कराना पड़ता है. फॉर दैट ऑथेंटिकेशन वन विटनेस टू द विल has to travel to India or has to give witness, has to step into the witness box through a video conferencing facility or whatever, and say that the will was made in his presence. The only mistake mostly people, so UK mein, like whatever the thing we see with the wills is that lawyers make the will, so the lawyers stamp the will, right? They might have a witness who is of course a clerk of the lawyer's office or somebody. They do not have a witness who is outside that office. So अगर वो विल का विटनेस इंडिया में नहीं आया और उसने वो विल को स्टैम्प, कोर्ट ने यहाँ से स्टैम्प नहीं करा, एंड देयर इज एन ऑब्जेक्शन, सो दैट विल इज कंप्लीटली यूजलेस फॉर द इंडियन स्टेट.
ओके.
सो बिकॉज हमारे पास बहुत सारे लोग आते हैं, लाइक इन फैक्ट आई रिमेम्बर इन फैक्ट वी हैड समबडी, अ जेंटलमैन इन लंदन इटसेल्फ. So he had a will of his parents. He came to us. The wills were probated by the courts in UK as well. Now, to get those wills and get the properties transferred in India, we wanted one of the witnesses to come to the court. The lawyer refused because, of course, they're Gora lawyers. They said, we can't go to India and give an evidence or whatever. We've got the will probated and that's about us. There was one witness who was a clerk to the lawyer's office. We couldn't track him. We could not come to the court. Now, the client was Mr. Desai. His sisters say that this will is not a genuine will. It does not apply to the state in India. And the sisters got away with that. Because हम लोग will नहीं prove कर पाए थे, because one of the witnesses has to come if the will is disputed or the transfer inheritance is disputed on the basis of the will, then it becomes a major point of concern क्योंकि कोई witness ही नहीं आता. So again, the advice on this bit is that when you're making a will and you want to make it in UK, do it in UK. But have two witnesses on the will who could, if in ever there is a chance, can travel to India or can step into the witness box to prove the authenticity of the will, to prove that the will was made. It's a genuine will. The person who made it voluntarily. He made it in his complete senses. Because
Okay.
a lot of old people make wills or they make wills and then people say ki he was of old age, he did not include his Indian assets, there is no person who can come down to India to prove, so the will goes. It's of no relevance and it's of no use for the Indian estate.
So, as what I understand, that the UK will be accepted subject to witness confirmation. But is it compulsory or is it advisable that they should make us two separate will, one for UK or one for their India asset or one for the global asset and one for India asset? Is it something, or is it fine with the one will is UK will mentioning all the global assets?
Here again, it's a personal choice. As long as you have two witnesses on the will who will come to it, who, if needed, can come to India to give the witness and to go step into the witness box, or even agar video conference honi hai and they can give an affidavit to that effect, it is perfectly fine. You can make one will. But yes, I would always suggest that instead of making your UK assets also complicated and Indian assets also complicated, you can make two separate wills where you can mention your Indian estate, go to the Indian High Commission, get it stamped from the Indian High Commission, to have two friends who are close friends who you can trust, who can, if needed, will stand by the contents of the will.
Okay, so what I understand now from the inheritance law is that the law is India across same except for Kashmir, but it's based on the religion wise, what religion you follow, will be accordingly there. There is no inheritance tax in India. Of course, once you per sale after that, then of course you have to capital gains and those things are there, which can be understandable. And it is advisable that you need to have a will which will take care of the process much easier, and it will be pass it on to the proper whoever you want to pass it on to it. So that's way. And of course taxation in UK and India is a difference. So in India it is much simpler as inheritance law as compared to UK. So thanks for the clearance and clarification about inheritance, because inheritance is definitely one of the most important issues we face as in an NRI market, and we see a lot of questions arises on those
Because
things.
second and third generations UK में बहुत है. And a lot of people have ancestral property back home or their parents, because Indians have a mindset where they want to keep themselves connected to the roots in India. And for that, they eventually end up buying one property or the other, or their parents or the great grandfathers have not disposed of their assets. So it is on the second and the third generation to look after that assets. So they have to very much understand how the inheritance laws will take place. Of course, everybody Googles. आज की date में internet is so easy, so everybody Googles and finds it out. But उसकी जब actual में implementation होती है, it is very different in India.
No, thank you for this clarification. That now that brings us to go to the next topic, which you have put up, which we have today discussion is illegitimate of children. So
Yes.
I understand, in the Western world, people have been started living without marriage, and they have kids and they have children. And as again we have, as I told you, inheritance law. This is again, if it is an inheritance law, if they have a children, not because of marriage, but as a civil partnership or a partnership, or they have adopted the children. Is that will that children will be applicable to get an inheritance, or what are the laws in India says about this thing as well? If you can give us a guidance, that would be really helpful.
So, Mihir, the law in India does not differentiate between legitimate and illegitimate children. A child is a child. Adopted बच्चा है, but adoption में the documentation has to be complete to prove that he's an adopted child. कल को कोई dispute raise करता है उसके लिए. अब illegitimate children is a term which is used for, of course, relationships and children born out of the wedlock. So there, of course, हमारे पास बहुत matters आते हैं where people have relationships back home in India, or they have relationships there. They have not, it's not culminated into any kind of a marriage, but they're children out of that relationship. So they all come and ask, we don't have a right in the property. Why not? All children have a right, the same right. Suppose a person died, उसके दो शादी से बच्चे हैं, एक बच्चा उसका एक other relationship से है, that child will have the same right as the children from the marriage have. So अगर 3 बच्चे रह जाते हैं उस आदमी के मरने के बाद, तो उन बच्चों को equal right मिलेगा. अब सिर्फ एक concern होता है कि whether the lady will have a right in the property or not. अगर किसी की wife जिंदा है already and he's not got married to another lady, but he was living with her, or he has a child from her, that lady will not have a right unless he's got married to her. The lady will not have a right, but a child certainly 100% has the same right as other children in the property. There have been so many instances where people have had contractual marriages for traveling abroad and getting their PRs or their citizenships abroad. Contractual hoti hain, but fir bhi they do end up having children in those relationships too. Those children have the same right as any child would have in the property.
Okay,
unless the man or the woman makes a will where they completely cross this child from having a right.
But then if that will again has to be, is that child
can be challenged, and again वो depend करता है, because बहुत बच्चों को पता होता है कि हाँ हमारे parents के और भी बच्चे हैं, so they get a will made. A lot of people in UK suffer from dementia. So this is another very common concern. Like UK में a lot of people have dementia there, and children or the family makes misuses this problem and makes them sign documents. So yes, like the child who is not from that wedlock but out of the wedlock, he can still challenge the contents of the will, because as a child he has an equal right in the father's property, and it's not even in the father's property, he also has a right in the ancestral property. अब ये जनरली लोग सोचते हैं कि एंसेस्ट्रल प्रॉपर्टी में इलेजिटिमेट बच्चों का, या जो बच्चे एक पार्टनरशिप से आए हैं या एक फ्रॉम अनदर रिलेशनशिप से आए हैं, उनका राइट नहीं है. A child has the same right as other children. This child will also have the same right as other children in the ancestral property, in the joint Hindu family property, in anything that father or the mother owns.
Okay. So that gives us a lot of insight on those information as well. Now, just to on that, the continuation of the inheritance or law, what are the rights of daughter? Normally, it is like assume in Indian that whatever the inheritance will go pass it on to the son, because son is the one who is being things. But I understand there are a lot of new regulations which gives a lot of rights to the daughters as well. So, would you like to give some insight on this as well, please?
So daughters, देखो अगर आप inheritance laws देखो तो daughters का तो शुरू से right है property में, parents की, father mother दोनों की daughter का equal right है. जो concern इंडिया में arise हुआ था, जो properties पे arise हुआ था, वो ancestral properties थी, joint Hindu family properties थी, जो वो family की अंदर की property थी. तो customary law ये होता था इंडिया में, क्योंकि लड़के घर में रहते थे और लड़कियों की शादी हो जाती थी and they would be a part of another household, they never wanted that family to interfere in the joint family estate or the ancestral property. Henceforth, the women did not before 2005 have a right in the joint Hindu family properties. So the daughters, married or unmarried, married daughters का right नहीं होता था. तो 2005 में एक amendment आई जिसमें उन्होंने daughters को married हो unmarried हो इक्वल राइट दिया है फादर की हर प्रॉपर्टी में, चाहे वो एंसेस्ट्रल हो, चाहे वो हिंदू जॉइंट फैमिली प्रॉपर्टी हो, या वो घर हो, क्योंकि वो जो विलेजेस में घर होते थे वो हिंदू फैमिली प्रॉपर्टी होती थी, तो वो कहते थे कि लड़की की शादी हो गई है उसका उसमें कोई राइट नहीं है. जो जद्दी प्रॉपर्टी आ रही है, जो वो अपने आगे क्या कहते हैं फादर ग्रैंडफादर से इनहेरिट कर रहे हैं, उसमें लड़कियों का कोई राइट नहीं होगा. आज की डेट में a daughter has the same right as that of the son. There is no distinction between a right of a daughter and right of a son. So inheritance laws are the same when it's like inheritance laws में जब मैंने शुरू किया था आपको बोला था सारे बच्चों का बेटे बेटियों सबका equal right बनता है, but वो एक आदमी की self acquired property थी. When we are talking about rights of daughters as such, rights of daughters even in the ancestral property in the joint Hindu family property is the same as that of a son in the family.
Okay, so that's gives us a good knowledge about the idea about it. Would you like to give any knowledge on these last three topics we discussed today further? So that would be.
So I'll just conclude this that generally it becomes very complicated for people to understand. You know, some people come and ask a question कि ancestral property है, इसमें तो बहन का right नहीं बनता. ये तो जॉइंट हिंदू फैमिली प्रॉपर्टी है, इसमें बेटी का राइट नहीं बनेगा, ये तो हमारे बेटों को जाना चाहिए, ये बेटों को ही आएगा. सो इनहेरिट अगेन आई विल जस्ट सम एवरीथिंग अप. फर्स्ट थिंग, inheritance laws are based on your religion. If you're a Hindu, you're a Sikh, you're a Jain, the Hindu Succession Act applies to you. But if you're a Muslim, the same law does not apply to you. It's a Muslim personal law which applies. अब Muslim personal law के बीच में भी there is a distinction. There are two schools, Shia and Sunni law. So Shia की inheritance अलग होती है, Sunni की अलग होती है, because that will need another one webinar to discuss the Muslim laws. It's very detailed. It's way more complicated and detailed than the Hindu personal laws. Now, that is one thing. Secondly, there is no distinction state-wise. कोई state है, कहीं भी है, वही laws apply करेंगे inheritance के लिए. सिर्फ फर्क तब आता है, inheritance तब cross होती है जब कोई आदमी will बना लेता है. अगर किसी a male or a female have left behind a will, then the will overrides the inheritance laws. But the will, to prove its genuinity, has to be made voluntarily, has to be made without any illness, mental illness nahi honi chahiye, and has to be in the presence of two witnesses who can come back and state in the court ki will unki presence mein bani thi.
So one question has come: the will, the witnesses has to be a family member, or they're known or unknown or related or not related people. Has to be just a question has come up.
The will, witnesses should be generally people who are known to you, but they should not be beneficiaries of the will. ऐसा नहीं होना चाहिए कि अगर मेरे फादर मेरे नाम पे विल कर रहे हैं और मेरी बहन के नाम पे विल कर रहे हैं, so उसका husband becomes a witness, because eventually वो भी तो benefit करेगा, उनके बच्चे भी तो benefit करेंगे. So there are two people who have to be witnesses to the will, who should be other than from the beneficiaries, but should be known to the family.
Okay, fair enough. Yeah.
And this is for inheritance. Then again, coming back, there is no distinction between children born from the marriage and children born out of the marriage. Children are children. It does not matter contractual relationship, civil partnership, or any other. A child to a man is considered as his child, and he will have the same right in every property that he owns, whether it's ancestral, his self-acquired, joint Hindu family property. He'll have a complete right in the father's property.
Sure. Okay.
Then comes again, concluding this part, similarly goes for the daughters. The daughters have the same right as that of a son. There is no distinction on the basis, there is no difference as of date, thankfully, under the Hindu law, on the basis of a daughter and a female and a son. A daughter and the son are considered equal, even if a daughter is married and is not living with the family or whatever, she will also can claim a right in the ancestral joint Hindu family property or a joint family house owned by the father or the family.
Thank you very much. Thank you, Manisha, for this inside knowledge. And I hope everyone who have attended this have got a lot of information. And if you have any query further, you can write to